Before we even get into the details, let's set the stage, because this case is about to spiral fast. You've got a defendant who already pleaded guilty, meaning he told the court, yes, I did it. But now, his story is shifting, and judges do not take that lightly. This isn't just about a simple mistake or a one-time lapse in judgment. This is about credibility, consistency, and whether the court believes a single word coming out of his mouth. What makes this even more intense? The stakes are massive. We're talking about repeat offenses, a long criminal history, and a judge who is clearly not in the mood for excuses. And as you'll see, the moment his story starts unraveling, everything changes. So here's the question you should keep in mind while watching this. Is he telling the truth, or just trying to minimize the damage? Because by the end of this hearing, one thing becomes crystal clear. This judge is not easily convinced.
Okay, so Mr. Segura, when you were here and entered your plea of guilty, I asked you some very specific questions about pleading guilty freely and voluntarily, and then pleading guilty because you actually did what they charged you with, and your answers to both of those were yes. The version, however, that of your version that I received here in the pre-sentence report is a little different. It says that you didn't have the drink until your vehicle was stopped. And so your version, if I'm to believe it, is that you stopped at the Taco Bell.
Yes, ma'am.
You drove to the Taco Bell.
I drove to the Taco Bell.
You stopped at the Taco Bell and you drank while your vehicle was stopped.
No, ma'am. I was outside the vehicle when the officer.
So you hung out at Taco Bell.
I was
and drank.
I was waiting for the line to move so I could get my food.
I asked that the defendant be sworn.
Yeah. Let's do that. Raise your right hand. You
Yes.
swear or affirm that the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
Okay, so you're saying that you got to Taco Bell. You drove to Taco Bell,
Yes, ma'am.
okay?
I made a right turn with my signal and everything. Then I was about to park my vehicle.
Mhm.
That's where the swerve came in at. Okay.
Right here, things start getting messy. The judge is trying to pin down a very simple timeline, but the defendant keeps dancing around the details. Was he parked? Was he in the drive-thru? Was he inside or outside the car? These might sound like small details, but in a courtroom, they matter a lot. Why? Because inconsistencies like this can completely destroy credibility. If you can't clearly explain where you were and what you were doing, how is the court supposed to trust your version of events? And notice the judge's tone. She's not confused, she's testing him. She's giving him chances to clarify, but every answer seems to raise more questions. So let me ask you, does this sound like someone recalling events honestly, or someone trying to adjust their story on the fly?
Obviously, it has to be. And then so.
I'm not worried about, hold on.
Yes, ma'am.
All right. I want to know, when you got to Taco Bell, regardless of whatever happened,
Right.
did you go through the drive-thru or
No.
did you park?
No, ma'am. No, ma'am. I
Listen to
parked-
my question. Did you go through the drive-thru or did you park?
I parked my
Okay.
car.
So when you parked your car at Taco Bell, you start having alcohol at that point?
No, ma'am. I got out of my vehicle to see how far the traffic was up in front of me.
Okay.
They had several cars in front of me. I
In
wasn't
front of
even-
you for what? You were parked.
Yeah, I was parked like,
Were you parked in a parking spot or were you
No,
parked in
ma'am.
the drive-thru?
I was not exactly in the drive-thru. I was at the end of the store. At the end of the store,
Okay.
but I guess you could consider that the drive-through line.
Were you waiting for the
I was
drive-thru?
waiting for the drive-through to
Okay,
proceed
listen,
because-
here's the thing. You're not going to try to trick me up with semantics
No,
today.
ma'am.
Hold on, don't talk over me.
Yes, ma'am.
When I say, were you going through the drive-thru or were you parked? What does that mean? That means, did you park your car because you're going to go in the store, or were you waiting in the line to go through the
I was
drive-thru?
actually waiting to go through the drive-through.
Okay. I may look, I don't know, like I'm 12 years old and just fell off the turnip
no,
truck,
ma'am.
but I'm not.
No, ma'am. I'm
So
not.
you're,
Now we've hit a critical moment, because the defendant finally admits he started drinking at Taco Bell. But here's the problem. His explanation still doesn't add up. He claims he drank most of a 40-ounce beer in a short window of time, and somehow that explains everything. From a legal standpoint, this is huge. Blood alcohol levels don't lie. They're backed by science. So when someone's story doesn't match the numbers, it raises serious red flags. The judge isn't just listening. She's calculating, comparing, and evaluating whether this explanation is even remotely plausible. And here's the bigger issue. If he's minimizing how much he drank, that suggests he's not fully accepting responsibility. And in court, that can directly impact sentencing. So what do you think? Is this a believable explanation, or is something being left out?
You're in the line and you get out of your vehicle, right? Because
Yeah.
there's a long line. The
Right.
cars aren't moving.
Right.
Right. So you get out and you decide, I'm going to start drinking here in the parking lot.
No, ma'am, I didn't drink until I got back inside my car.
Okay. But while you were at the Taco Bell, you started drinking. Had you drank before that?
No, ma'am.
So you're telling me that you started drinking at Taco Bell.
Yeah, I opened the container. That's how the beer came. It was on the floor.
So
of
from the
vehicle.
time that you started drinking at Taco Bell to the time that the officers got there, about how long was that?
Maybe 15 to 20, 30 minutes, whatever.
Okay. How much did you drink between that time?
I had a malt liquor. The
Mhm.
211 is a strong beer.
Just one?
It was a 40 ounce.
Right. So you drank the whole 40
I was
ounces.
drinking out of the thing. After the fact that
You were drinking out of what?
after I stepped back in the car, I started drinking it.
Right.
And
So
then, so
how much of it did you drink?
I consumed a lot of it.
Okay. So let's just say you drank most of
Most of it.
one 40 ounce.
It was getting contained.
So that's your story and you're
I
sticking,
sang
hold
beer.
on. So is that your story and you're sticking with it, that you drank most of one 40 ounce beer in about 15 to 30 minutes and that you hadn't drank anything before then?
No, except for that night before, about 2 o'clock that morning. And
Okay.
then whole blood, alcohol stays in your blood system, added to what I drank.
Okay. So your test on this night after drinking most of a 40 ounce was 0.188. And you're wanting me to believe that that's based on most of one drink, and that maybe you still had alcohol in your system from the day before.
Yes, ma'am,
Okay.
but what I recalling my memory, ma'am, I have no reason to try to trick you, Miss West. I'm telling you the God's honest truth. Like I said, I had alcohol in my system from the night before.
Well, how much did you drink the night before?
Well, I was intoxicated.
So what you're telling me then, if
And
you
hold-
hang on. So if you had that much alcohol in your system from the night before, that you were still,
This right here is where the judge completely dismantles his argument. She walks him step by step through his own logic and shows exactly why it doesn't make sense. If his blood alcohol level was that high, and he claims it came from earlier drinking, then that would mean he was likely intoxicated while driving to Taco Bell. That's a devastating point, because now, no matter which version of his story you believe, he's in trouble. Either he drank at Taco Bell and the numbers don't match, or he was already intoxicated before getting there. There's no clean way out. This is a classic courtroom moment where the judge uses reasoning to expose contradictions. And honestly, it's hard to come back from this. So ask yourself, did he just trap himself with his own story?
probably
I
hold
wasn't.
on. Watch where your story's going.
Yes, ma'am.
So you're telling me you had so much in your system the night before that it was going to still be in your blood, and you had just driven to the Taco Bell.
No, I drove into the Taco Bell that later on that evening,
You're not right.
but it wasn't a full 24 hours,
Right.
right?
So if you're saying that 0.188 is because of the night before, then all likelihood you were drunk when you were driving from the night before, if I'm to believe your story that you only had most of one drink while you were there. See how that doesn't make sense?
Yes, ma'am.
Okay. All right. So let's go back. Obviously there's some medium acceptance of responsibility, so we can go forward with the arguments unagreed. Mr. Coleman, you have a witness?
Yes, Your Honor. State Cause Troy Robinson.
Mr. Robertson, if you please raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may proceed.
Your Honor, the court's familiar with Mr. Robinson and his background, but
Sure.
for the purpose of the record, Mr. Robinson, you're certified as a fingerprint expert. Isn't that correct?
That's correct.
How long have you been certified as a criminal expert?
Almost 6 years now,
Testified in court before?
multiple times.
You've had an opportunity to review some documentation in this case?
Now the case takes a serious turn. We're no longer just talking about one incident. We're looking at a pattern. 20 prior felony judgments? That's not a small detail. That's a lifetime of legal trouble being laid out in front of the court. In sentencing, prior history matters a lot. Courts don't just look at what happened this time. They look at whether the defendant has learned from past mistakes. And here, the record suggests the opposite. The prosecution is building a narrative. This isn't an isolated incident. This is someone who keeps repeating the same behavior. And when that happens, judges are far less likely to show leniency. So now the question becomes, should someone with this kind of history get another chance, or has that ship already sailed?
Did they include prior judgments for the defendant, Mark Anthony Segura?
They were.
I'm showing you what's been marked as State's Exhibit Number 1. Is State's Exhibit Number 1 a fair and accurate summary of the 20 previous felony judgments that you reviewed in this case?
It is.
Using your
For 20 felony judgments.
I apologize. 20 previous prior criminal judgments, including a number of felonies.
Correct.
Okay. In other words, both misdemeanors and felonies.
Yes, sir.
And did you use the defendant's admission to at least one of the DWIs that he pled true to that had a print on its judgment to compare to the judgments here that had prints on it?
That is correct.
And what was your determination?
They're the same person.
And in addition to the prints that you used to compare and confirm his identity on these judgments, were there also some personal identifying information such as date of birth, SID numbers, and that kind of thing that you used to link to this?
Correct. As known as identifiers.
Okay. Your Honor, at this time, I would offer State's Exhibit Number 1, which is a summary of the judgments and the actual judgments themselves that are marked as State's Exhibits 2 through 20. For purposes of record tender to defense counsel.
Let me just ask, are there any on that list that aren't already on the pre-sentence report? I mean, why are we
It's
doing
been a while
both?
since I looked at the judge. I did think that there was at least a couple of those judgments. It's been a while since.
Mr. Burbank, does your client,
I'm gonna,
hold on, does your client have any objection or any reason not to, for me not to take judicial notice of the PSI for sure, that those prior offenses listed in there and the ones that are convictions are any way wrong?
for the misdemeanors, that's correct.
Okay, so what about for the felonies? Are there one or more that are, contest? So what I show with convictions on the PSI, I've got a 91 possession of a controlled substance. There was a probation that was revoked for 5 TDC.
Yes, sir.
Got a 96 manufacturing delivery of a controlled substance, 1 year jail. I've got a 03 possession of a controlled substance, 18-month state jail.
I have that.
I've got an 03 from April manufacturer delivery with 6 months state jail. I've got a January of 15 obstruction or retaliation, 2 TDC.
Yes.
I've got at the same date, a harassment of a public servant, 2 TDC. I've got a driving while intoxicated, 3rd or more. Offense date of 11 of 15, 3 TDC. And then I've got an 18 obstruction retaliation with 5 TDC. That totals 8 felony convictions.
That's more than what I had in my summary, Judge.
Okay. So are there then, I need at least whatever you have, because he has pled not true to the ones alleged in the indictment, which, let me pull that up.
Yes, Judge.
Y'all can just go sit down and take a break for a minute.
Yes, Judge.
Don't leave the courtroom, Mr. Segura.
Yes, no, yes, ma'am.
There, because it was reduced, there wouldn't be a
I do not see an SID number, no, ma'am.
evidence that has been included in the
This is where things get official. The judge is now making formal findings on prior convictions, and this directly impacts sentencing. Every true finding strengthens the prosecution's case and increases the potential punishment. But notice something important. The judge also finds one allegation not true due to lack of evidence. That's key. It shows the court isn't just blindly accepting everything, they're weighing each piece carefully. This balance is what makes the process fair. But even with that, the number of confirmed prior offenses is still significant, and each one adds weight to what's coming next. So here's something to think about. Even with one charge dismissed, is the overall picture still too overwhelming for leniency?
PSI as well as States Exhibit 2, 6, and 7, I'm going to find that the prior criminal offense felony in cause number 15-23847, which is number 15 in the state's enhancement, is true. I am also going to find State's Exhibit number 6, which is cause number 15-22572, which is number 14 in the state's notice of enhancement, make a finding that that is true. In addition, State 7, which is cause number 18-30235, which is number 16 in state's notice of enhancement, I am also going to make the finding that that is true. So that are those 3 prior felony offenses. I have made findings of true. I am taking into consideration all of the other ones, with the exception of state's number 5, which has not been introduced, but that was, we discussed, which is cause number 60328. I am going to make a finding of not true because I don't have enough evidence in that. It sounds like in that judgment to link Mr. Segur well enough to that offense. Everything else I'm taking notice of for punishment purposes.
And I know this is minor, Judge, but does that include the 2096, let me show you, in the PSI, in which he received 1 year before we believe before the state jail?
I just said that a minute ago. So in 96,
Okay, that's the one.
I'm taking notice that that was reduced and is not a felony. So, and what that means is that it appears as though there are this would be the maybe the 7th or 8th. All right. So yes, I took judicial notice that that one was reduced from a felony to a misdemeanor back on the with argument on sentencing.
If I may, I'd like to call my client.
Yes, and he's already been sworn in. Thank you, Mr. Robinson. Go ahead, Mr. Segur or Mr. Burbank.
We're here today, Mark, to determine what punishment should be in reference to this. Tell the court why. Well, what are you asking for in punishment? Let's start with that one.
First of all, Miss Judge, ma'am, I'm asking for mercy, for forgiveness to begin with. I'm not a bad person. Miss West, I completed high school. I had 1 semester in college for auto mechanics. I've served for the community. I worked all my life. The kids was out playing.
Where have you worked?
I worked. I worked for Little and Willis when I was a kid at the age 15. After that, I graduated and I continued working.
Now we're seeing the human side of the case. The defendant is asking for mercy, talking about his life, his work history, and trying to show he's more than just his record. And to be fair, this is a critical moment, because sentencing isn't just about punishment, it's also about perspective. But here's the challenge. When someone has a long criminal history, words alone aren't always enough. Courts want to see change, accountability, and effort to improve, and the judge is clearly questioning whether that's happened here. There's also an emotional element, loss, hardship, personal struggles. But the court still has to weigh that against public safety. So what do you think matters more here? His past struggles or his repeated offenses?
I've been working in the plant for over 30 to 40 years. All my life, I've been working.
How many years?
Building scaffold
Mr.
and all different types of jobs all over.
Mark, how
Yes.
many years did you serve in prison? How many years have you been in prison?
First of all,
How many years have you been in prison?
all together with everything, I done did over, 10 years.
Okay, and how old are you?
I'm 58 years old.
58 years old, and for 10 years, you've been in prison in DWIs and other things. So what mercy are you asking for from this court when you have 19 misdemeanors and 6 or 7 felonies? Why should she consider something less? I mean, give her a reason why.
Miss West,
What's changed?
I didn't do half of the things that they say I did.
Mark, you pled guilty to them, okay? That's
Yeah.
over with, right? The day for you, in reference to court, the day for you to say, I didn't do this is over. You accepted a plea, okay? I mean, let's cut to the chase here,
Yes,
because she could find the allegations, well, she did, the true and under consideration, and it's 25 to life,
yes,
okay? And I guess the most you've had up until this point is 5 years, correct?
yes.
Okay, so now let's go first to when you were arrested. Were you working?
I'm receiving disability. I can't work no more.
Okay, what is your disability?
I got rheumatoid arthritis. I got prostate problems. My heart is bad.
Are you on disability?
Yes, sir.
Okay, and when were you placed on disability?
Like 2020.
Okay, so 2020, you're on disability. So while you're on disability, why are you drinking beer 40 ounces at a time? Or drinking the night before to where you're tired?
There's no excuse.
Explain to her.
I just lost my brother. I lost my mother and my father. And alcohol just don't bring it. They're not gonna break me.
Okay, so you have a problem.
I have a problem.
One of the things we talked about was, when you came to me was that you never went into a program.
Never.
You never went into a drug program?
I never had a chance on probation and that.
Well, you got.
Well, what about when you
probation.
weren't on probation? What about the times when you weren't in prison? You knew you had a problem and you wanted to stay out of
Yeah,
prison?
well, I got a device since I've been home. What do you?
No, what, that's since
Oh,
you've
yes,
been in,
ma'am. I tried.
I'm talking about the rest of your life. I'm talking,
This moment is brutal. The judge lays out the full extent of his record. Public intoxications, traffic violations, missed court appearances, it just keeps going. And this isn't just about numbers, it's about behavior over time. When a judge sees this kind of pattern, it sends a clear message: prior punishments didn't work. And when that happens, courts often feel they have no choice but to escalate consequences. What makes it worse is the perception that he's not fully owning it. The judge even calls the process a circus, which tells you exactly how frustrated she is. So let me ask you, at what point does the system stop giving chances and start focusing purely on protection and punishment?
about the times that you got
Yes, ma'am.
arrested 43 times for public intoxication, 39 traffic offenses, 17 times you didn't appear in court, 5 disorderly conducts, 4 open containers. I mean, these are the ones that aren't even listed on the pages.
Yes, ma'am.
Pages.
Miss West. They have 5 different other marks again.
Okay, so you're gonna
In the
stick with
system.
that this isn't you.
No, ma'am. I'm not making no excuses. I have very much high respect for the
Well,
officer of the law.
Okay. Do you
Okay.
really? You
Yes,
do?
ma'am, I do.
So that's the 19 misdemeanors, the assaults, the terroristic threats, the
I-
trespassings, the 1, 2, 3, 4. This is your 5th DWI, your 2nd felony DWI. By what you need to understand
Yes, ma'am.
is that by not really taking personal responsibility and making us go through this circus that we've been going through now for an hour and a half of trying to prove that you actually have been convicted of felony offenses,
Yes, ma'am.
when you know darn well that you have,
Yes, ma'am.
makes no sense to me.
Yes, ma'am.
Mr. Coleman,
I have no questions for the defendant, Judge.
argument.
Just briefly, Judge, you have everything you need, Judge. We're asking that you sentence this defendant to the minimum of 25 years. He put himself in this situation, Judge.
If I
Go
may,
ahead.
Judge. One of the things in reference to the priors, maybe semi my fault, Judge, because if I did not object to him, to me, it would, and he pled true to him, then it would automatically go to 25 to life without the consideration of full range. He's got a problem, and he spent most of his life in and out, and it's alcohol related. I throw one thing out, Judge, but it is alcohol, and he was in a vehicle, and there is a big risk in this. Is that you place him on 10 years deferred probation, you find true to the allegations, you send him to safety, but if he screws up, he's looking at a minimum of 25 to life if you find those true, so that if he comes back. Here's the problem is that we don't know what happens when he comes back, what the new offensive violation is in reference to this. But I have done it before, Judge, in other courts where you could give him deferred.
I can't give deferred on a driving while intoxicated. Now, we've done that on other types of,
Yeah.
You're starting with the beginning of this hearing when we were going.
We're in the final stretch now, and both sides are making their last arguments. The defense tries to suggest alternatives like probation or treatment, emphasizing his alcohol problem. And that's a valid point. Addiction is real, and rehabilitation can work. But the judge isn't convinced. Why? Because she's looking at the full picture, the inconsistent story, the high blood alcohol level, and the extensive criminal history. And from her perspective, the risk to public safety is simply too high. This is where legal theory meets reality. In theory, rehabilitation is ideal, but in practice, repeated offenses can shift the focus to punishment and deterrence. So here's the big question. Should the system prioritize rehabilitation here, or is this a case where punishment is the only option left?
Through the just the nature of the offense.
Yes.
Starting there, we went down the wrong path. It makes no sense. I don't believe it. It doesn't add up to what your blood alcohol level was. How you say what happened that night doesn't line up. It just doesn't. I get that 40 ounces is a big beer, but if you've been an alcoholic for as long as you're talking about, that's not going to get your blood alcohol to what it was that night, which was almost a 0.2. It was a 0.188. And I have already found those 3 prior offenses true. Those are all felony offenses from different conviction dates. I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated, third or more. I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. In my opinion, you're lucky that Mr. Coleman asked for 25, because I'm not sure that you really even deserve that with your criminal history and with how you have refused to accept real responsibility. You will receive credit on this sentence for any time that you've been in custody, that the law gives you the right to receive.
And just like that, the verdict is in 25 years. The judge makes it clear, this decision isn't just about this one incident, it's about a lifetime of repeated behavior, missed opportunities, and a failure to take real responsibility. From a legal standpoint, this case highlights a few key lessons. First, credibility matters. Once your story starts falling apart, it's incredibly hard to recover. Second, prior history plays a massive role in sentencing. And finally, courts have limits, especially when public safety is on the line. This wasn't just a courtroom exchange, it was a turning point, where the judge decided enough was enough. Now we want to hear from you. Do you think this sentence was fair or too harsh? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.